same reasoning, if the Supreme Court says so, in the judgment, we will understand that.
That is correct. That is correct.
Yes, please place some other judgment.
Please.
I'm not convinced. Yes. Lissus matter in the month of October. Huh? They'll
October 16/10.
let him have the. Yes, next.
Cell number 15. Cell number 15. Renuka HR. For appellant
Well,
Jagdish HT.
I find this appeal, my lord, as against the conventional heads, my lord. Kindly see the synopsis, my lord. 3 lakhs is awarded towards loss of love and
No, we'll calculate afresh.
I think
Yes.
if it is calculated, it will
It's
be
more
more,
than-
my lord.
It will be?
It will
7,000
be
has
much
taken.
more than that, my lord.
So I'll
Your lordship may kindly reduce the rate of interest, my lord. It's
From?
9%.
9%.
Please.
Please
If he had filed an appeal, probably it would have been enhanced.
agreed with the award passed in MVC number 1759 of 2017 dated 27 November 2019, whereby the tribunal had granted compensation of an amount of rupees 11,84,000. The KSRTC submits that the tribunal has awarded an amount of rupees 3 lakh.
3 lakhs towards conventional heads, my lord.
Relax.
And
And
for the claimant, the respondent submits that. In fact, the claimant does not preferred appeal. Had they preferred the appeal, they would have, the amount that is already granted with the tribunal is not a reasonable one. The amount would have been enhanced. Next para. This court has perused the order impugned and also the calculation that is made.
my lord, your lordship may kindly say, my lord, 7,000 is taken.
Hmm.
And if these 2017 accident, 11,000 would have been
The
taken.
court had taken 7,000 and now as this accident had taken place in 2017,
17 accident.
it should have been 11,000.
11,000.
1,000 plus
11,000. And on that count, if it is calculated, the amount would be more. In those circumstances, this court is not inclined to interfere with the order as far as the compensation is concerned. Then counsel submits that the interest is awarded at 9%, hence the same needs to be reduced. Accordingly, the appeal of the KSRTC is partly allowed by reducing the reducing the rate of interest from 9% to 6%.
Please,
Accordingly, partly allowed, and that amount in deposit shall be forthwith. Yes, next.
Cell number 16. Uday Kumar RL for appellant Adini
We
Shivanand.
have for second respondent. my lord.
Payments have been only on quantum, my lord.
Yes.
The accident is on 16.
case of death or injury?
2016.
Death or injury.
Injury, my lord.
Please
Injury.
come to the
Fracture.
table. Come to the table.
In this, my lord, future loss of income is not considered.
We'll go to
Disability
the
is not considered. That is the issue.
What are
Disability is
the,
not
what are the injuries?
Injuries numerous.
Only one.
One,
fracture.
no, another one is posterior hip injury, my lord.
Dislocation of posterior shaft.
Dislocation of vestibular.
Another
All of
10,000 for pain and suffering.
Pain and suffering 50,000 is given, my lord.
Another 10,000 will grant.
Please.
Medical expenses
That is actually was given.
as it is.
And the
Come to
special-
the table at the page number 16.
Please.
We'll go each head.
that-
3,93,889.
my point is, my lord, disability is not considered.
We will discuss. How many days he was in hospital?
11 days, my lord.
Attendant. So 11,000. Then
So that due to the accident injuries, the patient sustained a 30.15 disability to the whole body. As per the admission of the petitioner, he continued in his job
Oh,
and in the same company, and he has 25,000.
30.5% disability to the whole body is a very big thing.
That is working in a proprietary concern, my lord. He is a chartered accountant firm.
Are you able to hear the court?
Is page 11 of the judgment, my lord.
That I have seen.
He has continued in the, he has
No, no.
continued in the job.
No, but the 30.5% disability to the whole body is a considerable disability.
Yes, my lord. Yes, my lord. But he has continued in the job and he has received more salary.
So
salary
it
also.
would have a lot of impact on his life.
Another submission is in a
Sir, loss of
proprietary,
amenities
is
could be increased.
working as an assistant in a chartered accountant firm. It is a proprietor firm. Tomorrow you may tell, don't come. See, there is no guarantee, man. Even he is not working in at least private company,
But
there is
that is not,
What is the
but that
evidence?
is not the evidence given, my lord.
evidence is there, my lord. In his
No,
deposition, he admit that they.
My lord,
I'll
my
record.
lord.
I'll record that.
Yes, my lord.
Loss of late down period is not given, my lord. That also.
1 minute, 1 minute. Whole body disability is 30 point.
30.5 minute.
What is the multiplier?
My lord,
Multiplier.
multiplier is 13.
13.
1313.
48 years, my lord.
48, yeah, that's it.
It's coming to 12,48,975 under the head of loss of future loss of income. That we will not consider then. Then future that we will not consider then. Then future medical expenses.
20,000 is granted, my lord.
27 is granted.
That we are granting another 10,000.
Something that ಅದು ಭೇಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ
It's coming to 13,69,975 against 5,28,889. Please come.
My lord, my only submission may be noted, my lord.
That I'll write.
Fractures are united. My lord, according to the doctors, fractures are united and his salary is increased as per his.
To 25,000 it is increased. That cannot be a ground for the court not to grant any amount under the head of loss of future income. It is submitted that 30% disability to the whole body is a considerable disability which would have a great impact on his income. As is in a private job, there is no security to the said job, and basing on that, the court cannot deny the claimant the compensation under the said head. It is submitted that considering the hip dislocation and the fracture, and even at the head of pain and suffering, also the amount that is awarded by the court is not reasonable. He submits that he is in hospital for 11 days, and the court ought to have granted 11,000. Coming to the loss of amenities also at 30, considering the 30% disability, court ought to have granted the loss of amenities. It is submitted. The insurance company submits that the court had rightly not granted loss the nourishment. Considering 11 days of hospitalization, this court is granting 11,000. as per the evidence of the doctor, the claimant had sustained 30.5% disability. Hence, under the head of loss of immunities, this court is granting 70,000. Future medical expenses, the court had granted 20,000. Considering that the accident had taken place in the year 2016, this court is granting 30,000. Then coming to the loss of future income, it is not that the claimant is in a secured job. That cannot be a reason for the court not to grant future compensation. Then coming to the submission of the letter of insurance company, that the doctor who has treated who has disability to 30.5%. 30.5% disability to the whole body will have a very great impact on the future life of the
17.
what is this? We don't have the papers. No representation for the no representation on behalf of the appellant. Counsel, the respondent is present in 17.1. Mr. Ravi Sampati is directed to take notice, and the learned counsel for the appellant should serve the copy of the appeal memo listed to next week. Yes, next.
Then number 18.
My lord, I am for appellant. Claimant's appeal, my lord.
Where is Mr. Yes, Mr. Sitaramarov. Yes.
My lord,
Yes, ma'am.
My lord, facts in nutshell is, my lord, deceased was crossing the road. A car dashed against him, and thereafter he fell down, and a minibus came and ran over on the deceased, and he died on the spot. My lord, tribunal rightly consider negligence aspect, car 47%, minibus 40%. But since there is no pedestrian crossing, my lord, only on that count, 20% is foisted on the deceased. My lord, my submission is, if there is a pedestrian crossing, suppose if he violates and try to cross the road other place than pedestrian crossing marked. But in such circumstances, my lord, these may be correct. My lord, in highway, my lord, suppose if you...
Very novel interpretation.
My lord,
You are getting very novel.
the accident is of the year 2019, my lord. The accident is of the year 2019, my lord. The income required to be considered 14%. Well, 10% is to be added. Tribunal has considered 9,000.
It is 14,000.
Yes.
14,000. What is the age?
My lord, 54, 10% is added, my lord.
Court had taken?
The 9,000, my lord. 9,000. He claims 15,000. He's a cleaner in the lorry.
How many are the dependents?
My lord, a wife and 2 sons. Remaining heads, my lord, I have no case. I am not... only quantum and negligence. My lord, 11, my lord, 11. That is correctly applied.
It is coming to 24,64,000. What about the other?
Estate 15,000, funeral expenses. Need not interfere. Out of 24 lakhs, my lord, some 10% my lord is deducting.
Okay. $25 lakhs, 98,000. No, some small mistake in the calculation. It's 1400. Instead of 1400, a small mistake in the calculation. 15,400. Is 5,000. Coming to 10 to 1,000. So 56. Yes, 13 lakhs, 55,244. Is 1,48,924 has to be deducted. It comes to 13 lakh 40,320. What is the liability? 50-50.
40 is 10% on me, my lord. That is
As well, questioning the contributory negligence that is fixed on the claimant, fixed on the deceased at 20%. The claim petition is filed, seeking compensation of an amount of rupees. How much is sought? 25 lakhs for the death of the deceased. 8 a.m. was crossing the road. At that time, driver of the Etios car drove it in a rash and negligent manner, came from Bangalore towards Mysore side and dashed against the deceased. As a result, he fell down and suffered injuries. At the same time, driver of one minibus came from Bangalore side, drove it in a rash and negligent manner without keeping proper distance, and the said bus wheel ran over the body of the deceased. As a result, he suffered severe head injury and immediately was shifted to the hospital, wherein he was declared as broad dead. The tribunal has held that there is contributory negligence, that has held that both the driver of because of the negligence of the the driver of Etios car and also minibus, there is negligence on the part of both the drivers, and has held that both the drivers as well. The court said when there was no pedestrian crossing as he was crossing the road, the 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 contributory negligence is fixed at 20% on the claimant and the deceased, and accordingly granted the compensation. Then counsel appearing for the claimant submits that fixing the contributory negligence at 20% on the claimant is without on the deceased is without any basis. It is submitted that the clear negligence of both the drivers is established. In that case, the court ought not to have fixed the contributory negligence on the deceased. It is submitted that the compensation that is awarded is not just and reasonable, and the same needs to be enhanced. Then counsels appearing on behalf of both the insurance companies submits that the court had rightly considered and uh, fixed the liability on the fixed the contributory negligence on the deceased, and there are no grounds to interfere. Next para, having heard so and so, so and so. This court has perused the order impugned and the manner in which the accident has happened. It is a clear case where there is a negligence on the part of the drivers of both the vehicles. However, there is, however, there is contributory negligence on the part of the claimant, but in the considered opinion of the court, apportioning the same at 20% is on the higher side. In that view of the matter, the contributory negligence is apportioned at 45% on both the vehicles and 10% on the deceased. Then coming to the compensation, this accident had taken place in the year 2019. The income has to be taken at 14,000. 10% future prospects would come to 4,000. That is 15,400. And there are two claimants, one third has to be deducted towards personal expenses, that is 5,133. Then his contribution to the family is 10,267 into 12 into 11 is 13,55,244 under the head of loss of dependency. Then when it comes to the loss of consortium, 88,002 into 44, that is 6,000 funeral expenses. In the light of the law laid down, 10,000 is the legal expenses. Altogether, it comes to 14,18,244. Then as the contributory negligence is fixed at 10%, it comes to 1,48,924. The same is deducted. The compensation amount would come to 13,40,320. That amount, both the insurance companies are liable to pay 50% of the same. Accordingly, the appeal of the claimant is partly allowed, and it is held that the contribute and by reducing the contributory negligence, but that is fixed on the claimant from so and so, from 20%,
20%. 10.
and the insurance company is liable to, both insurance companies are liable to pay 13,40,320.
The appellant,
Yes.
Dhananjay Kumar,
Where is the other side? No representation on behalf of the uh, uh, claimant. This is marked in the month of December. Yes, next.
cell number 20,
Refer this matter to the Lok Adalat. Yes. Huh? Lok Adalat.
Yes.
Yes, next 20.
20, Pradeep B. For appellant, Shiv
Yes,
Kumar SK,
Hearing for the appellant in this case.
Hmm.
In this case, my lord, challenge liability, my lord. The
Ground.
involvement of the vehicle itself is questioned. There is no complaint and FIR, my lord. The filed a ECA matter before the MSCT, contending that, my lord, deceased was working as a sugar cutter, and he was boarded the tractor and trailer after cutting the sugar cane, and the tractor and trailer turned turtle, my lord. Due to that, he has sustained injuries and succumbed to the same. But there is no complaint and FIR in that regard. Only medical bills they have produced. Apart from that, they have not placed any material.
Further learn counts for the appellant, no representation for the respondent. This is matter, give some date next week. Yes, next.
20, 25, 9. Cell number 21, Sripad V. Shastri,
My lord, actually, Pradeep is to wakalat, my lord.
He knew that he will do it. You please argue.
A claim under 163A, my lord, motorcycle, deceased was traveling riding the motorcycle. It dashed against another vehicle. My lord, tribunal disowned the liability on the ground that the motorcycle is belonging to another person, and he borrowed the same. That is why company not liable. And as far as another vehicle is concerned, my lord, since he is negligent, my lord, going to the tortious liability. My lord,
Let us read that particular finding.
Para 27 and 28.
Please read.
my lord, if by Lord permits, my lord, I am ready. Issue number 2.
I think you can come to.
However, in order to counter the above argument, the ruling of the
Case of
counsel
death
for
or
the
injury.
Yes, of death.
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 Then won't he step into the shoes of the owner of the vehicle?
but my lord, as far as other vehicle is concerned, my lord,
Himself is a tortfeasor, my lord. Charge sheet, abetted charge sheet filed against the rider of the motorcycle. Deceased, my lord.
my lord, as far as negligence aspect is concerned, it's the jurisdictional aspect. Tribunal has no jurisdiction to entertain the jurisdictional aspect. Tribunal has no jurisdiction to entertain the question of negligence. My lord, liability, my lord, even it is found to be correct that I borrowed the motorcycle from other person, even though that principle is not strictly applicable. But another vehicle is there, it is insured. My lord, the liability of another vehicle cannot be disowned. Now, the matter is simple. Well, it's the accent between a motorcycle and the another tractor. It's tractor.
So in an application filed under 163A, you don't have to prove the negligence of the
Yes, yes, yes,
other
yes,
vehicle. But
yes.
if the charge sheet is filed against you, what is
Yeah,
the
no, no, my lord, that is irrelevant, my lord, because it is that since tribunal has no jurisdiction to entertain the negligence aspect, well, date may be given, my lord, otherwise.
only wherever the compensation has to be enhanced, you argue, and for these matters by date,
Alan, because my lord, the principle
this
is,
also will decide. This also will decide. You argue.
my lord, the accident, the deceased was riding the motorcycle belonging to another person.
Yes.
My lord, there is a collision between a tractor and trailer.
Yes.
Death and involvement and insurance is not in dispute.
Yes.
My lord, I made both the vehicles as party. My lord,
Yes.
as per the 163A is a non-obstante clause.
Hmm.
My lord, the tribunal cannot entertain the question of negligence. Only apportionment, my lord, tribunal can do. Like a social welfare legislation to give some remedy to the deceased parents, that is legal acts. Well, this provision is made. That's why there is ample, there is citations, judgments of the apex court as well as this court. Well, the negligence aspect cannot be entertained.
Yes.
It is a question of jurisdiction. My lord, since tribunal has no jurisdiction to entertain the question of negligence, my lord, the liability, my lord, the tribunal can disown the liability of the motorcycle. My lord, since even though there is a judgment of this honorable court that borrowing, stepping into the shoes, my lord, that principle does not applicable here. But I am not argued against this judgment. Well, the liability of the tractor trailer remains, Mela. Merely because charge sheet is filed, that cannot be disowned.
Yes, Pradeep. Yes, please read. Have you heard his submissions? Have you heard his submissions? What do you say? No, according to him, tribunal has no jurisdiction to deal with under 163A to say that somebody is negligent. Why there are views taken in that, like there are some judgments in that regard also, saying that even though he's a tortfeasor, still she is entitled under 163A. No, there must be no Supreme Court judgment on that, on the 163A.
Now, my lord, that provision is taken
1
away.
minute, yes. No, there is no authoritative pronouncement of the Supreme Court that it has to be returned. I mean, pronouncement of the Supreme Court that it has to be returned. I mean, larger bench of this court or the Supreme Court or apex court. Recently, I think you have. So we'll defer.
That is, my lord, only one vehicle involved. Only.
Remember that. Then we'll also defer this. This is smarter.
My lord,
Yes, next.
sorry, my lord, sorry. If I disturb my lord, I'm extremely sorry, my lord.
It is submitted that the Honorable Apex Court has referred the matter with regard to the liability of a tortfeasor under section 163A of the Act, in that view of the matter, this matter in the month of February.
Then number 22.
Malad, one submission, Malad. Malad, I have some personal inconvenience in 2:30. Say list number 5, Madam.
February.
February.
No, that's not the way you mentioned the,
Injury case, my lord, climate also 8 years, my lord. I'm relying the same.
that's what morning.
Please, my lord.
You have given, already I've seen the judgment. We'll defer that. Kajal's case, how can it be applied in every case? We'll defer that. We'll post this matter in the month of February.
Please, my lord.
Yes, one.
List number 2, serial number 1 for being spoken to.
Who moved this?
Please, I have moved a memo for
Respondent,
this.
but
It was
we are
rightly
on-
dictated, madam.
we are together on this small typo error, my lord.
The operative portion, my lord, sir.
1 minute.
Please.
Yes. Yes.
That during the pendency of the petition, the petitioner shall continue to pay 20,000 per month. That is from today. It should have been, that is from today, my lords. That the next portion should have been gone to the third para. That's only the,
No. So,
from the date, please,
two,
please,
it
please.
should be during the pendency of the petition. The petitioner shall continue to pay 20,000 per month. That is from today.
It should have been from today, my lords. That was rightly dictated, but only a typographical error has been. My lords have rightly dictated it, but
Yes.
That last line to be removed, my lord.
that removed and should go for third, my lords.
Of petition criminal miscellaneous number
Yes,
till.
that
Till today, that
will
should go to para 3, my lords.
Yes.
Please.
So it has to go.
To 3.
Arrears have to be calculated.
Please,
It will be
please.
10,000 per month.
From the date of, please,
of,
please, my lords, please.
it
My
is,
lords have dictated
jumbled.
it from, it is jumbled, that's it.
To be calculated at rupees 20,000 per month. No, from here, per month. Another in clause number 3, arrears have to be calculated from the date of petition at 10,000 from the date of petition in criminal miscellaneous 27 of 2020. This court has perused the order. Hence, as submitted, the correction shall be carried out, inverted commas, so and so, in clause number 2 and clause number 3.
That's-
To the corrected copy shall be uploaded.
That's one more request, which I have, now I have seen, my lords. My lords had said that if there is any failure to pay, last sentence, my lords, sorry, my lords, shall pass appropriate orders under section 151 is what my lords have mentioned, but it's a 125 petition under CRPC, my lords.
Oh.
They may say that 151 is not applicable. That's only, shall file necessary application if my lord says that is,
Appropriate orders as per law,
please, my lords.
say in clause number 3. As per law.
Please, my lords, more straightforward.
Arrears, my lord, arrears at 10,000
Please, please, that's correct.
Arrears.
That is correct.
till
Amount is
date
correct.
of this order. That is 31/8, if I'm right.
That is correctly, that is,
8, if I'm right.
that is correctly, that is there then, my lord.
Only
7,
It is,
sorry.
yes.
It's
next.
jumbled, that's it.
Yes.
Because otherwise, again, we'll have to.
What is that?
No, if otherwise,
No, it says
Arrears is from the date,
50,000 from the date of order.
this order.
It says
Arrears is from the date,
50,000 from the date of order.
this order, please.
correct.
It's at 10,000 from the date of petition.
Petition.
Till 31/7, which is the date of order
Date
of this.
order.
That also will clarify.
Please.
Give that order.
The petitioner has not complied the order passed by this honorable court.
That's what the advocate, at least he should come to the court.
Petitioner's advocate is not coming, my lord. He says that, no, he is not coming to me, he is not
What is not
responding.
coming? As long as the court permits him to retire, it is his duty of the advocate to come and represent.
Yeah,
Even if the basic, this thing, if the advocate is not aware, then court cannot help it. So unfortunate. In spite of an order, where is that? Give the record proceeding. A memo of retirement is filed just by filing the notice that is sent, and no acknowledgement is filed, and no representation is before this court. By filing, will not permit the advocate not to represent before the court. List this matter. Rupees 10,000 to be paid to the legal to the Advocates Association. Let it continue in the same dismissal list.
Sale number 3, hearing on interlocutory application. Ramesh P. Kulkarni for petitioner, S.V. Prakash.
Yes.
Respondent.
Under section 125.
Why the delay of 370 days?
But, he was suffering from TB, and there was intervening corona also, and he
When
was.
is this? Let's see your section 5 application.
I have produced the doctor's this advice, my lord.
No. We will see your the affidavit that is filed under section 5.
Yes, ma'am. From para number.
When is the order?
The order was passed, my lord, on
5/11/20.
9th March 22. The order was passed, my lord, on
5/11/20.
9th March 22.
Sorry, sir.
511?
Sir.
511?
9th March.
9th March 22, my lords.
9th March?
22.
22.
Now, where is the corona in 9th on 9/3/2022?
My lord, he was having TB. Therefore, he was put into a secluded room.
Let's read, or where did you say?
And he lost one eyesight and having a high sugar. Para number 5, my lord. Para number 3, first page of the affidavit. We led a happy life till it was diagnosed that I am suffering from.
What is the amount that is granted?
7,000 odd, my lord.
How much?
7,000 for wife, 4,000 for
We will
two
consider
children.
this and will pass orders on the merits of it.
No, my lords, because intentionally he is not prepared in time, my lords. We have taken paper publication also, and after that we find.
Where you filed your wakalat. Then why did this time take from, at least we'll kind of count it from that date, not from 9/3. We'll look at it from 23/5 where you appeared before the executing court. For that, you don't give any reasons in the affidavit. It's a general statement.
If your lordship permits me, I will file additional affidavit. My lord, he's almost zero, my lord. Nothing, and then the trial court, my lord, also did not follow the procedure before placing ex parte. But that has happened, my lord. It has not followed rules 60, CRPC section 62, 64, 65, 67.
What? Because the party who is not coming to the court after issuance of notice, you can't plead all this.
Lords, in the execution petition, now arrest warrant is issued against him, my lord. His counsel is also not appearing before the court, my lord.
Only one house was there. I had purchased it jointly with my wife. My lord, they
Is
compelled.
it true that he has purchased the property and he has gifted it to you?
Actually, my lords, it is purchased by my father in both name, my lords, in our favor. After that, he released his rights in favor of me, my lords. He is earning from medical shop. He owned a medical shop. He is earning more than 70,000 per month.
At least you don't even accept what are the medical condition of the petitioner.
They have not produced any documents, my lord, except stating in the affidavit, they have not produced anything.
Along with
In
the
the-
application, I have produced the prescription of the doctor, my lord.
Where is it?
Along.
But if it is case is genuine, at least he should have appeared before the execution court. I may be permitted to pass over this, my lords.
What is that?
The execution case order sheet, my lords. In that, arrest warrant is issued against him, my lords. After filing wakalat, He did not appear before the court, my lords.
It was on 21/8/2023. What is the latest position?
Now arrest warrant is issued. I have checked in online, my lords. It is posted for 31st October, my lords. 31st October, my lords.
Oh, we have to look at his financial capacity also in those circumstances.
Instruction
And
is-
what is the financial capacity of the wife? Now, there is a house, there is a house, there is a, he says 2 portions or 3 portions. You must have rented it, you must be earning something. Have you filed your statement of assets and liabilities?
The learned judge also says to ascertain the evocation
I
income.
understand your submission as far as the latches on his part are concerned. Now, then the next point is about the financial capacity.
My instruction is that he is running medical shop, my lords. Even though I have not produced any document to show that he is running medical shop, but
What is your income?
I'm not working, my lords. I'm depending
You're
on my
not
father.
working apart from.
PW2 is my father. He deposed that since he is now aged, he can't maintain in my house, me also.
No, house is there. House is rent. You must be getting some income out of it. He has relinquished his share. Give deed.
My lords,
Get instructions from your
please,
client.
I will get instruction.
This is matter next week at the request of learned counsel. By the time the learned counsel, the respondent shall get specific instruction. What is the income of the, what are the sources of income for the wife, and from the house which is constructed by the husband, according to the husband by him, and where the wife is residing, whether part of the house is rented, is it rent, what is the rent she is realizing from it. Yes, next.
24/9. Serial number 4. Serial number 4. Venkat Reddy.
Petitioner, but an application, recall of the order, it was dismissed for non-prosecution. The matter was listed before this court on 18/7/2025. I had taken time for only 1 week to get the steps against the respondent. I verified the address, whatever the address furnished by before trial court. The respondent is not there, she has vacated the address.
No, paying process is your duty. You should do it.
So whatever the address given by the respondent before trial court, same address was given before this call. When I verified the same,
Not verified. A week's time is granted to do the needful. Needful is to pay the process.
I may permitted at least to serve the notice to the trial court advocate as well as the party by hand in this.
Or trial court advocate, RPFC, any execution is filed.
Execution is filed. It's pending before the family court.
No, that you should come before the court and do it at an appropriate time. No, we can't pass every day one order, recall that order.
I can understand, but thing will be already, she has changed the address. Respect there.
Is it on paying of the process or not? Furnishing of so and so, for issuance of notice. Because you have not paid the process, it is that is as it's a default order.
Permitted to recall the order, I may permitted to file the process.
Why should we do it? That's the question.
Next week, it's
Huh?
2 days.
I said, why should we do it? This is your writ petition is a RPFC of the year 2024.
Please.
When did you file this? For years together, the matters will be pending without even notice to the other side. That is past, that is 14/8/2025 is when, how can it be 14/8/2025 when the RPFC is numbered in 2024?
2025 application came.
The order dated 7/1/2025 is complied, then we will see.
Oh, please.
An IA number 1025 is filed to recall the order dated 18/7/2025. By the next date of hearing, an affidavit shall be filed before this court, whether the order dated 7/1/2025 is complied with or not. If it is complied with, how the payments are made.
Serial
Yes,
number
next.
5. Serial number 5.
Next week.
Muslim.
Next week.
Why? How many next weeks?
Taxi.
The party shall appear before the mediation center on 6/8/2025. Mediation report received, not settled. It's this matter on 12/6/2025. By the time petitioner shall place before the court what are the efforts made by the wife for securing a job. This court by order dated 6/6/2025 has directed the wife to place a document before this court. What are the efforts made by her to in securing the job? No such affidavit is filed before the court. List it on so and so. By the time, if it is not filed, the petition shall stand dismissed without further reference to the court.
25/9.
Yes.
For admission matter, serial number 6. 6. Satish Chandra KV.
Non-filing of acknowledgement for having paid the interim maintenance.
No, there is already counseling is there in before to your chamber, Lordship. She is the PhD.
Both are the PhD.
Both are appear before in the chamber. According to that, the petitioner is the lecturer, and she was a PhD doctor. Doctorate is holding. Now the trial court is order for 15,000 rupees. Decree of divorce is already completed. He is already gotten a second marriage and a children and age-old parent. Then I am ready to give the 3 lakh rupees for the permanent alimony for the respondent. She's a PhD graduate, doctorate is there, and gotten a job also in Shimoga city. But because I know I'm living in the Mangalore rented house, only I got 43,000 rupees as a salary.
No.
He is demanding 15 lakh, but the husband is ready to pay an amount of 3 lakh. Both the parties to have further deliberations. So she wants only the 15 lakh.
Huh?
No, ma'am.
Huh?
No, ma'am. I'm ready to accept the 10 lakhs also, but he is not ready to give.
I'm ready to pay for 3 lakh rupees
Only
and
3 lakhs
arrears,
is
Your
asked.
Honor. I gave the
Arrears would come to how much?
huh?
Arrears would come to,
nearly 3 lakh. Part payment was already paid in the court also.
mean to say 3 plus 3.
Nearly 3 plus 3, nearly. I'm not accurate.
Arrears is 3 lakhs and he is ready to pay permanent 3 lakhs.
Permanent
I am
alimony.
asking 10 lakhs now.
Because I'm already married. I got a child, age-old parents. She's an only
How much
doctor.
is the amount granted by the court?
In the trial court is 15,000 rupees.
15,000.
Tell your client because she's earning, will reduce that amount. If the amount is reduced, tell her what consequences.
Because
follow.
you
Tell her.
Yes.
If this court reduces that amount, because not even reducing, why is she entitled when she's working?
No, she is a temporary lecturer and the daily,
listen,
weekly 3 or 4 classes
How
is
much she's
taken.
earning?
Per period 400 to 500 months.
no minimum
That is
wages
a, that
is
is a,
there.
that is a
I'm sorry.
government college. That is a fixed
36,000
daily,
rupees.
per period.
36,000 rupees per month
No.
for a guest lecturer to all Karnataka because she's in a doctorate in the physics. Once suppose she's
Tell your client that what are the consequences to follow. He is ready to pay 3 lakhs and whatever it is, let her take. Or else we have to reduce the amount. This is matter, give a date. By the time land counsel respondent should get specific
26/9.
instructions from the client. What is, whether
Serial number 7. Girish B. Bandale.
Petition, my lord. Husband petition, my lord. There is an ex parte judgment passed against the wife.
Kindly see the order sheet, my lord. 19/4/2022.
huh?
Order sheet, my lord. Kindly see. 19/4/2022.
Part order.
Ex parte order.
Ex parte order, my
Ex parte judgment has been passed against the
It will
My
be
lord,
passed if you don't
IA
appear
number 2,
before
file the stay application.
6,000 interim maintenance was granted by the court below, family court. And
How
this
much is granted?
6,000, my lordship. Is
What is your income?
There is no assets and liability filed by
No,
the
what is your
petition.
income I'm asking?
Income is 9,000 to 10,000, my lord.
What do you do?
I'm agriculture coolie, my lord. They have stated that
Agriculture coolie will earn more than this. We'll earn at least 15,000 a month. Even minimum wages also.
and I'm claiming, I'm disputing the relationship, marital relationship between the husband and wife. And my main contention is she's not the legally wedded wife of the petitioner.
We will give you that opportunity, provided you pay the amount 6,000 with all the arrears. Then we will ask the court to decide that issue.
Six
Otherwise, we
yes.
can't give you that opportunity. When you,
My lordship, that what is the amount awarded by the family court is
very minimum amount.
slightly exorbitant, my lordship, because 6,000, when he was earning not more than 10,000, 6,000 itself, the maintenance amount has been awarded by the court below.
First of
The
all,
interim order was granted subject to payment of.
Subject to condition, pay the amount of rupees 3,000.
3,000. I'll continue to pay that amount.
But
my
not till
lordship.
date, not filed any amount paid.
I will pay the entire arrears.
Till
lordship.
date, not filed any amount paid.
I will pay the entire arrears along with any due.
and even that 3,000 also you have not paid the.
I am
arrears.
I am paid, my lordship. I paid the amount. Whether it is
2022.
completely paid or not,
Counsel,
whether it is completely
2022.
paid or not,
Counsel for the respondent as well as the petitioner shall file a calculation memo before this court. And as per the order dated,
2020,
an interim order without complying, the court would dismiss the RPFC on that ground.
already passed the order, my lord, 29 to 6, 2022.
Where is
Kindly
that?
see order sheet.
29?
6, 2022. By the
29.
petition, the petition
Minute,
is
1 minute,
itself
let
would
me
be
look at the
dismissed.
order. Please wait.
well, I have got a receipt, my lordship. I will pay the interim maintenance, whatever the amount awarded by this court.
Give that, take that one.
Subsequently, the receipt is not in my.
I don't find such an order. 29? He's telling something. Ask him where is that order. Show it to him. Where is that order?
29 6 2022 only. Learned counsel for the petition submission that within a 1 week there would be deposited all the arrears of maintenance as per the order dated 19/2. The learned counsel for the response submitted that no, even the single rupees
What
has
is this?
been.
I'm not able to understand this.
That is the receipt, my lordship, for payment of the interim maintenance as ordered by this honorable court.
No, it is 20,000.
Before
What is
last,
that? What is
End
that?
of September.
before last, before
What is
last,
that? What is
End
that?
of September.
before last date of hearing, there was a submission from the petitioner saying that he's a deaf and dumb, and the evidence recorded by the trial court, he was not understanding the contents of the cross-examination questions and all, and your lordship had directed them to file an affidavit to that extent. Lordship may kindly see the entire evidence has been recorded, and that has been part and parcel of the record. A CD is there. Chief examination and cross-examination have been recorded in terms of the Evidence Act.
No, what is the affidavit that is filed now? Saying that he's deaf and.
Now they are refrained, they have gone back. Lordship may kindly peruse the para 6 of the affidavit. It is at their instance, here a speech expert was appointed and evidence was adduced through her at their instance. Now they have gone back against that. Para 6, I submit that at the time of recording evidence before the learned family judge Tumkur, I was
Where are you reading? Para 6 is not there.
affidavit, my lords.
Yes,
I
para
served
6
the
starts
copy.
with, I submit that my son. Yes, yes. Dated 23rd June 2022 is this affidavit.
They have filed an affidavit. Yes, that affidavit. Para 6.
What it says?
Para 6. I submit that at the time of recording evidence before the learned family judge so and so, I was unable to follow and understand the translation made to me during that time. In view of
Petitioner paid in online, my lord. Petitioner paid in online, my lord. I will ask. 1 week
Yes.
rest, my lord.
Pay?
My lords, until 13th of July, my lords, I have paid 45,000, my lords. There was an order of this honorable court to pay 5,000 every month. After the July 2024, they have not been paying that
So how
amount.
much has to be paid now?
My lords, 70,000 is pending, my lords.
70.
70 till date.
As per the interim order.
Please, my lords.
The amount as per the interim order, the entire amount shall be cleared within a period of 1 week, or else the RPFC will be dismissed on that ground. Yes, list that mine, give a date. Yes, next.
2 weeks.
25/9.
Yes, next.
Cell number 10. SV Prakash.
Non-depositing of 50%.
He is not in a position to deposit single.